Used it? Is it?
Yes, it is.
Missed it?
Yes. Richard Birivumbuka, Chief State Attorney for Prosecution. My colleagues, Tumusime Kato, Ochida Hope, and Masaba.
Ochida? Mr. Tumusime Kato?
And Masaba Raphael Gideon, all for accused persons on private brief. Your Worship, this matter is coming up today for prosecution's reply to the accused application for bail.
Your Worship, before we get the reply from my other colleagues.
Just a minute. Just a minute. Just a minute, Counsel. Mr. Masaba?
Masaba Raphael Gideon, Your Worship.
Yes, Mr. Masaba.
Your Worship, I pray that before we get the reply from state, Your Worship, I did not appreciate the sensitivity of this matter. That yesterday I received a phone call from one of the sureties informing me that the chairman.
Yesterday I received
a phone call from one of our sureties, that is Nambozo, Brenda, the sister of the accused. She informed me that our resident chairman had questioned her why she had not informed him that the person he was introducing had actually abused someone very important. Your Worship, basing on that, we took steps and obtained another letter in respect to this confirming respect to the accused person.
As a result?
As a result.
You went somewhere else and you picked another letter?
Your Worship, we got a letter from the village where the mother of the accused comes from. And that is in particular Kakoli to Sale in Budaka district.
Kakoli?
Kakoli to Sale. It is in Budaka district. This letter, Your Worship, introduces the mother, the suspect.
Objection, Your Worship.
Yes, let's let him pass complete counsel with him. Yes, Mr. Masaba?
Your Worship, this letter in particular.
This letter introduces
the mother of the suspect.
As another surety.
No, and it confirms that during school holidays, the accused Musana Ibrahim spends his holidays with the mother. I worship, we pray that we submit this letter and the mother's photocopy of the mother's national ID.
So it's another, it is an alternative residence for the accused.
Yes, Your Worship.
Yes, let me look at them. Check. Sit. He's indicated as a businessman. Does he study? On the charge sheet, which is businessman.
Your Worship is a student.
And also businessman at the same time?
Your Worship, I don't
That's
know
what I have here. I don't know whether I have
Yes,
the same
Your
charge sheet. The charge sheet is indicated that he's a businessman. Later is saying that he's a student and sometimes in holidays he visits the mother.
Yes, Your Worship.
So what does he do?
I push adverts online. I do online adverts for work business.
You don't mind advertising for people?
Yes.
And so at the same time?
Your Worship, I only knew that he holds a TikTok account.
I'm not aware.
That's what I
I'm
was
not aware of TikTok account. I'm just reading it. I'm not on TikTok.
Much obligation.
Your Worship,
Let's proceed with your response. You will address this, I believe.
most obliged. Your Worship, today was the prosecutor's day to respond to the applicant's application for bail.
Yes.
Your Worship, we do appreciate that it is the accused's right to apply for bail.
Just a minute. Let me pull that. I do appreciate.
Yes, that is the applicant's right to apply for bail. But it is the discretion of this honorable court to grant it or not. When applying for bail, the applicant fronted two sureties. That is the numbers of Brenda and Ibrahim Sembatia Matia. Your Worship, prosecution sought to verify one, the validity of the recommendation letter to the accused person or the applicant. And the recommendation letters, the recommendation letter for the applicant, numbers of Brenda and Ibrahim Sembate. We instructed the police officer, Detective AIP Pambizo Akre, who is the investigating officer, one of the investigating officers in this matter, to ensure a thorough verification of the same. He did so and thereafter swore an affidavit which we filed, my lord, your worship, and served on to accused. Yes, this morning. It's okay. Your worship, let me refer you to the state affidavit, the verification, because it forms key in this. Your Worship, to confirm that he is the investigating officer in this matter, we refer to paragraph 2 of the said affidavit. Paragraph 2 of the said affidavit. And we appreciate, Your Worship, the fact that this accused person is charged with 4 counts of hate speech and malicious information. That is paragraph 3 of the affidavit. In respect to the accused person himself, Your Worship, refer to paragraph 6. The letter which introduced him was received, and we annexed it as annexure 3 in the affidavit. Annexure C. Yes. Annexure C. On verification, it was found out that the applicant, who is the accused person, has never been a resident of that place. The chairperson LC1 confirmed that through his letter, which is
he has never been a resident
of the place which is in the
that's that zone. Eh?
Yes.
So this is paragraph what?
This is paragraph 7 of the affidavit. His annexure is D. Is marked as D.
So the letter chairman confirmed the annexure D.
Yes. And Your Worship, that explains there's some connection between the chairperson's letter and the place where the accused person or the applicant was arrested from. The applicant was arrested from a hotel called Alexis, which is found in Tinda.
How long had he lived in the hotel?
He had been there for 2 consecutive months. And the implication of that is that he does not have a fixed place of abode, which is very critical to consider why court is granting or releasing him on bail. Your Worship, because the accused person does not have a fixed place of abode, it became extremely difficult for police to locate him and arrest him. I refer you to
Arrest him and
to locate him and arrest him. To locate and arrest him. I refer to paragraph 12 of the affidavit. Your Worship, they submit in that respect. In considering whether or not an accused person is eligible to be released on bail, the place of residence or fixed place of abode plays an important role because it speaks to the credibility of the accused person or the applicant, and the possibility of rearresting him in case he absconds bail. And when we talk about a place of abode, we are meaning a fixed place of abode. A fixed place of abode. Which is not here in the instant case. And Your Worship, allow me submit that a situation where an accused person exhibits no credibility, then who are we to assume his worth? Secondly, failure to have a fixed place of abode makes him a flight risk. Makes him a flight risk. That the chances of him absconding bail in case he's released are so high and in that respect, court cannot assume the risk. Your Worship, I will refer you to the case of Onebe Francis versus Uganda. Onebe Francis versus Uganda. High Court Miscellaneous Application number 222 of 2021. I'll furnish this court with a ruling on that. I would just want to quote something from that case, Your Worship, which is critical. That bail is founded on a trust system. Bail is founded on a trust system. And if any or the whole of this trust is put into question, the court cannot assume the risk of releasing the applicant on bail. And this is exactly that is happening in this matter. We pray that this court does not take the risk or assume the risk of releasing him on bail, since the trust in him is in question. Prosecution would have had nothing to say had the applicant proven that he has a fixed place of abode. Your Worship, I wish to submit that in respect to Sembatia Moses, Sembatia Ibrahim. It was, yes. Your Worship, it was, upon verification, it was found out that Sembatia Ibrahim is no longer resident. Is no longer a resident of the area, which appears in his introduction letter.
You have proof state?
Yes, Your Worship. I'm coming, Your Worship. In verification, Your Worship, in our affidavit.
Not paragraph 10?
No. I want to refer you first of all to paragraph 8. Paragraph 8. Where we attached his introduction letter, which is in dispute, as an extra F. as annexure F.
Yes.
Then I want to refer you to paragraph 10 of the affidavit, in which the chairperson LC1 was categorically clear that the said surety is no longer a resident of that place.
That's the same of Muzana
Yeah.
zone.
Yes, and that letter is marked as annexure G. I refer you to paragraph 10 of the affidavit.
Annexure G.
Annexure G.
Yes. This is Muzana zone. Do letters look alike? Let me have a look at this one. It's on record. Yes, they look alike.
Yes.
Okay. It's annexure. Proceed.
Yes, I'll come back to him as well, as I sum up for both. Then, in respect to numbers of render, Your Worship, we attached the letter introducing her as annexure E as per paragraph 8 of the affidavit. And upon verification, numbers of render is a tenant in one of the in that area, and she does not have a fixed place of abode. She's a resident, but she doesn't have a fixed place of abode.
Can shift any time?
Yes.
You mean she can shift any time?
Yes, and Your Worship will refer you to paragraph 10.
10?
Paragraph 10, yes. No, 9 of the affidavit. Your Worship, allow me to submit about those two sureties jointly. For a surety to be substantial or to be considered substantial, there are several considerations that court must look at. One of them, as I said earlier on, is having a fixed place of abode. Which does not exist in our instant case. The current residence of Sembatia is not known. Nambozo is a tenant who is temporal, that can shift anytime. And the applicant, much as is not a surety, cannot be placed anywhere. Now, the implication in respect to Ibrahim, the applicant, the surety, is that he lied to court, that he has a fixed place of abode. And those are all trust issues. The second thing, Your Worship, that court looks at is whether the surety is capable of meeting the bond terms in case the applicant absconds.
Whether the surety?
Yes.
You're capable of what?
of making good or paying the bond terms, executing the bond in terms of real payment in case the applicant or the accused person absconds. That one is demonstrated through the sureties themselves showing court that they have sounding businesses, which was never the case. They were simply talking about I'm a businessman, a business lady in places they couldn't even locate. No one can locate the businesses they were talking about. That is one loophole. Two, they have to show that by producing bank statements, which court can look at and stimulate it and say this person is worth entrusting the accused person or the applicant. None of them did that. It is also important to note, Your Worship, that another way of demonstrating that is by furnishing titles. By furnishing titles, land titles in this respect, to show that the surety can, in case the applicant absconds bail, can sell that land. First of all, show that he has a fixed place of birth or abode. Secondly, that he can sell that piece of land and reimburse. This was never done. None of the sureties presented is able to do so. Then the other way, Your Worship, is demonstrating as a surety that they know the applicant and where they live. In which case they are able to control the accused person in case he absconds bail. I want to just refer you. Ibrahim, one of the sureties, simply said he's a friend to the applicant. I don't know whether he's a temporary friend or a permanent friend, but simply said he was a friend to the applicant, and he did not mention to this court that he knows where he stays. Your Worship, that explains why even his residence is not up to date. Your Worship, I'm assuming that these accused persons were released on bail. Won't he go to another hotel? And in case he goes to another hotel, will the surety be in position to control him practically? None of the sureties has a passport. They don't even have a passport. The best they can do is to use porous borders in case the accused person absconds. And we have an experience of Kapwenza who was charged with the cyber harassment, who ran away. These are things we are talking about, and they are a reality.
Communicate to your lawyers.
We are talking about the sureties, not the accused person. Your Worship, I would like to refer you. I would like to refer you to the case of Mogera John versus Uganda. Mogera John versus Uganda. This is 0021 of 2023. 0021 of 2023. International Crimes Division of the High Court. This was by Lady Justice Alice Komhanj. Your Worship, while the judge was denying bail to the applicant she referred or she relied on the ruling of miscellaneous application number 002 of 2022 of 2022 by Honorable Lady Justice Elizabeth Jane Alibiza. Who, on page 11 of that ruling, emphasized the importance of credible sources of income for sureties. And in that case, because the sureties failed to demonstrate that it was a reason for denial of the application. Your Worship, I have a copy of the ruling of 0021 of 2023, and my submissions are based on page 13 of the same. A copy of the same is here, Your Worship. Then also for defense. And Your Worship, just to emphasize that, it is worse, especially when the matter is of public interest. This is a matter of public interest. The treatment given to matters of public interest is different from other matters. And where court finds that a matter is of public interest, then, Your Worship, Justice Margaret Tiburia emphasized in miscellaneous applications number 045, 046, and 047 of 2015 on page 10 of that ruling. Where she emphasized that in considering whether an accused person or an applicant should be released on bail, the needs of the society need to be protected. And one of the needs of society is protecting them from lawlessness. Your Worship, in this matter, much as the applicant is innocent until proven guilty, as prosecution, this matter is of public interest. And the only way the public interest can be protected is by keeping the applicant in custody until the matter is complete.
By keeping
the applicant in custody until the matter is complete. The applicant attacked very important persons in this country, that even his life is insecure. And actually being in custody is for his own benefit. Being in custody is for his own benefit. In fact, if I were him, I wouldn't even mention the word application for bail. First of all, Your Worship, I have a copy of this ruling for court
You are saying that he's safer in prison?
He's safer in prison, Your Worship. And Your Worship, it's not only speculative, but I would refer you to paragraph, just a minute.
In jail?
Yes, from the affidavit. From our investigations, Your Worship, is that there were clear signs that if the public just got hold of the applicant, he would be dissected into pieces. So he is safer in custody.
I would like to object to that.
You will get the time to submit. Proceed stage.
These are investigations. You can also present yours. Your Worship, is there submission therefore that the applicant is safer in custody? But besides, it is the applicant is an administrator of Pressure, of a Twitter account called Pressure 24/7. He's the administrator of that account. From my investigation, Pressure at Pressure 24/7.
At pressure what?
At Pressure slice 24/7. I refer to paragraph 11 of the affidavit. I refer to paragraph 11 of the affidavit. TikTok.
Yes.
TikTok. Yeah. Thank you.
Pressure 24/7?
Yes. What is the implication is that once he gets out of custody, the possibility of him deleting and interfering with the investigations are so high. And yet this TikTok account is a source of investigations. Josh, I'm not an expert, but once you're an administrator, then you're capable of doing anything on that account which you administer. Besides, that says
you're saying you interfere with investigation?
Yes, exactly.
In conclusion?
Your Worship, I just want to furnish you with a copy of the ruling of instance applications 045, 046, and 047 of 2015. Your Worship, yes. Your Worship, it is our prayer that you find the sheet is presented not substantial enough. I just want to highlight something small before I talk about the submission which my brother brought in later. When the applicant appeared before police, he presented his place of abode as Kauga Village, Mukono, Upper Mukono Municipality, Mukono District.
His place of abode as?
Yes, as per Annexure B. As per Annexure B. Page 1 of Annexure B.
Annexure B is the charge
sheet.
Where's it of Kauga?
Yes.
In Mukono.
In Mukono. In Mukono. Well knowing, with impunity, with dishonesty, knowing that he was lying. So, if he's fond of lying, should the court trust him? if he has exhibited signs of dishonesty, then who should place honesty? Who should believe that an applicant is honest? Our submission is that you agree with the prosecution that no one should trust him. And the only way you can not trust him is by ensuring that this application is dismissed. Your Worship, man and brother for the applicant sought to bring in another surety. Introduce another surety.
Is introducing a surety is just introducing a place of residence. An alternative place of residence. Is that a question, Mr. Masaba? Is introducing another place of residence. To make it 3.
To make it 3 residences.
Yes.
Which is very good. We do appreciate. What does that signify? That this court may not get him in anywhere, and none of these shooters, I don't know whether they're in court, will ever trace his residence or manage to prevail over him in case this applicant absconded bail. Having 3 homes for an applicant who is not a corporate makes him more of a flight risk, because he depends on phone to survive, meaning that he's not corporate. While other people go to offices, he's on phone to make money from phone. So that makes him too uncorporate and trustworthy.
So court can't trust the person who survives on a phone.
Where would you find him? Where is his place of address? Because, Your Worship, I don't want to speculate, but the issue of address is a matter of fact. But besides, prosecution pledged to verify the documents. If, for example, my brothers knew of that, maybe probably they took instructions prematurely without interviewing the applicant. I'm not accusing them, but they should have brought this information that time when they were making this application. This is an afterthought. This is an afterthought because they are operating no obstruct. As the prosecution is proceeding to verify the residence of the accused person or applicant, they are busy operating in abstract because we should have verified that. And now that we can't verify that, we pray that Your Worship Court finds him further doesn't have the express of a board. Your Worship, in a nutshell, this accused person, as per Annexure B, Your Worship, as per Annexure B, the accused person is charged with 8 counts, 4 for hate speech and 4 for malicious information, sharing malicious information. These are serious kind of charges or counts, which are multiple in nature. They are multiple in nature. Coupled with the fact that he was on fishing spree for witnesses, for sureties whom we believe are commercial, we pray that this court denies or dismisses his application for bail. To the worst, just in case this court has closed its eyes to these glaring gaps in this application. We pray to have that on record. Just in case this court closes its eyes on the glaring gaps in this application, right from the applicant, the sureties, then we pray for extremely stringent terms.
What amounts to extremely stringent?
Your Worship, bail term of about 30 million shillings. Yes, this is prosecution. I mean, this is prosecution.
So you pray that he pays 30 million cash?
We are saying in case, if court, which of course our prayer is that court should dismiss the application. But in case this court exercises its discretion, then the terms should be extremely harsh. Not harsh, but deterrent. Yeah. And Your Worship, these terms we are talking about, which we even don't want to mention, but for example, depositing a land title.
In his name?
Depositing a land title, if court is inclined, he has to deposit a land title in his name. Yes, demonstrate by way of an account to show that he's worthy, trusting himself. Your Worship, then also depositing his passport. Among others, we so pray.
Who is it, council? And one council is going to present for no, one council. Choose amongst the four of you and let one council declare the join.
Thank you, Your Worship.
Ms. Who is most senior? Who's Mr. Masao? Mr. Masao, please do lead the team.
Much of that, Your Worship. Your Worship, I have carefully listened to the Land Chief State Attorney. The Land Chief State Attorney's emotional submissions.
Objection, emotional submissions. These are professional submissions because they are based on law. I pray that you withdraws that.
Council, we withdraw the word emotional and then we proceed.
Yes.
Your Worship, with apologies, I withdraw. I was driven by that because
I'm writing your withdraw because that's an emotional submission.
Your Worship.
Just a minute.
First,
Just a minute. I'm withdrawing what you had to say.
much of that.
Now proceed after withdrawing. Yeah.
Your Worship, to start with, council submitted that the accused is charged with several offences. Your Worship, looking at these offences, they are not that grave in nature. Your Worship, a quick look at the punishment is between paying a fine and imprisonment of 1 year to 5 years.
What's the maximum period in prison?
That's 5 years, Your Worship. And the minimum is a fine. Your Worship, this is not a very grave offense, like murder. And even in murder cases, Your Worship, court grants bail. So I invite court to disregard the submissions that the accused has multiple offences against him as a ground for not granting him bail. Your Worship, counsel submitted that the accused does not fix place of abode.
And you are saying that he has a fixed place overboard where?
And Your Worship, we earlier informed the court.
The justice accused has a fixed place overboard at?
We still maintain that he has a fixed place overboard at Church Zone. And his mother's home during the school holidays in Budaka.
Address me on the business at Kauga.
Your Worship, I wanted to first address court on the letter recording the residence of the accused. Your Worship, the LC1 does not deny that he authored the first letter introducing the accused person as a resident within Church Zone. Not anywhere in his letter does he deny that he authored that letter. Your Worship, I would like to invite courts to our earlier submission that threats from investigating officers.
So you are saying that the chairman of this one was merely threatened?
Yes. It has not been denied authoring the letter introducing the accused person. These were threats by the investigating officer.
If it's from the back, let's proceed.
Matter of that, Your Worship. Your Worship, though, it was also, we state submitted that and gave an exhibit B, which is a charge sheet, where it is stated that the residence of the accused is Kauga village in Mukono. Your Worship, this is not trial that we are producing evidence. However, we note that the document state is relying on is signed by the officer preparing the charge and the magistrate. We do not have time to examine and find out how was this document prepared and brought in court.
So you are saying that this is a state document?
Yes, Your Worship.
So they know what they wrote?
Yes, Your Worship. And that is the officer preparing the charges. Your Worship. It is an allegation by the investigating officer that he arrested the accused from a hotel in Kisasi, where the accused had stayed for 2 months. Your Worship, there is no any proof or evidence attached to this affidavit that the accused person was actually staying in Kisasi. Your Worship, just as they have provided several evidence on this affidavit, there is no single, even a receipt from the hotel to prove to court, so invite court to actually disregard such evidence that is made by an investigating officer whose task is to ensure that the accused is left in cells. Your Worship, for the first time I had evidence from the bar that the accused is likely to be subjected to mob justice by my colleague. Apart from merely stating this in the affidavit, there is no evidence by the state that actually the accused will be subjected to mob justice. As we can see in court, Your Worship, the sympathizers are so many. I would pray that Your Worship will disregard the prayer of denying the accused the bail, and because there is a likelihood of any mob justice on him. Your Worship, further, the land chief state attorney presented to court that one surety Nambozo Brenda is a tenant and does not have a fixed place of abode. My simple understanding, Your Worship, of having a place of abode is that you have somewhere you reside. The ownership. Your Worship, I back up this with direction number 15 and the Constitution Bill guidelines for courts of judicature, where courts only has to get the, where you're considering a surety, court will look at the age, work and residence of the surety, but not that the surety should own a home for him or her to become a sound and substantive surety. Your Worship, the LOC even confirmed that actually Brenda is a resident within church zone. So I would pray, Your Worship, that court finds numbers of Brenda a sister to the accused, Your Worship, she's also older than the accused, so she has influence over the accused person by age, and she will ensure that he appears before court. Further, Your Worship, on the second surety, before this court we introduced Ibrahim Sembatia Matia as a resident of Muzana zone. And Your Worship, during the submissions I heard of Sembatia Moses.
It was withdrawn, and the proper to have is Sembatia Matia.
Your Worship, I did not hear counsel withdraw that.
The system records automatically.
Thank you, Your Worship. Your Worship, in this regard, the same spirit we informed the court earlier that the investigating officer has intimidated the LOC1 who introduced the accused person. We still see it on Ibrahim Sembatia Matia. The LOC writes a letter. He does not deny having introduced the surety to court. But he merely asserts that he does not know if the surety is no longer a resident in that area. Worship, I would pray that since the surety presented to court the Republic of Uganda national ID, which has not been found to be a forgery, because if it was, our state would have informed us, court should find Ibrahim Sembatia Matia as a sound surety since he can be ably found based on his national ID and his workplace. Your Worship, we had a state submit that the accused is likely to interfere with investigations since he is the administrator of At Pressure 24/7. So it's likely to delete. Your Worship, I believe by the time a file was compiled and taken to the state attorney to charge the accused, evidence had been collected that moved the land chief state attorney to sanction the charges against the accused.
So even if he deletes,
The
they will not be
evidence
affected.
Yes, Your Worship. Your Worship, we have 4 charges. We have about 8 counts If evidence was not there at the time of charging the accused person, they would not have charged all these 8 counts. We believe there is no likelihood of the accused interfering with the investigations. Your Worship, further, that even the investigating officer deposed an affidavit. It is evidence that actually he has collected the evidence. Your Worship, I don't have the authority with me here, but I'd like to cite it for court. This is Pujam versus Republic, PANGU versus Republic. Your Worship, it's the 1973 East Africa Law Reports at page 200. 1973.
East Africa.
Yes, at page 282. Where it was
It's
held.
PANGU.
Yes, versus Republic. It is the 1973 East Africa Law Reports at page
It was
200.
held.
And it was held that circumstances where an investigating officer has shown an affidavit it is court held that it was a simple act, that an allegation, fears or suspicions then the sky is the limit and one can only, there will be no occasion for bail if court believed that on just a mere allegation, fears and suspicion of the affidavit of the investigating officer, then the sky will be the limit and there will be no bail. Your Worship, also, we had the state attorney mention that the sureties should have businesses and should be people of financial muscle to qualify to be a surety. My Lord, in the simple duties of a surety is sound when he or she will ensure that the accused person appears in court. We humbly pray that this court disregards a prayer.
So it is not based on financials.
Yes, Your Worship.
Financial muscle is not the issue.
Yes.
Wind up, Council.
Your Worship, this was in Kayongo versus Bashir.
Kayongo versus Bashir.
Kayongo Bashir versus Uganda. Kayongo Bashir versus Uganda was a miscellaneous application number 158 of 2019.
2019.
Yes, where a court held that court noted that the onus is to prove a permanent place of abode and not to produce titles, prove ownership of property,
Not to produce.
and not to produce certificates of title, prove ownership of property, and produce utility bills. And Your Worship, state also prayed that should the court be inclined to grant bail,
Your Worship, I just want to understand that to prove onus is to prove what?
Let us to prove place of abode and not to produce titles, proof of ownership of property, and produce utility bills. That's what I can check.
that is in respect to the sureties, as my colleague.
And then you lastly on extremely stringent bill terms.
Yes, Your Worship. Your Worship, in alternative, we will pray that they are accused and the first surety Nangozo Brenda, they both informed me they have passports. They can surrender the passports to court. Your Worship, I would have also prayed for national IDs, but I'm guided by the recent guidelines where courts, where the principal judge guided that we should not retain the national IDs because they are needed more in day-to-day business. So I will maintain the prayer that they surrender their passports.
Finally,
Finally, Your Worship, the 30 million prayer would still maintain and pray that court is lenient. Considering that the fine, if court sentenced him to a fine of 70 currency points, would not even be more than 3 million shillings, Your Worship. I should put down a prayer for court to consider bail of non-cash. Thank you, Your Worship.
to go back and write this ruling and come back, I'll give you another day.
Your Worship, we shall humbly wait.
So just give me a few minutes, I'm going to come back. At 12:30.
Your Worship wanted to be on record just to disprove that the investigating officer never intimidated any person.
Because you have no right of reply unless you seek
Leave of court.
leave of court. We shall come back at 12:30. Court should be back to 12:30 for ruling.
Criminal case number 142 of 2024, Uganda versus Musa na Ibrahim, alias version 24/7.
I don't have a job. They don't want to give time.
It is considered before the matter should over for ruling. They already received it. However, I just want to counsel Nahab Precious, who was in court and is on watching period. Nahab Precious. We already received that ruling.
This is the ruling. We accused Musa na Ibrahim, also known as Pressure 24/7, to stand charged with 8 counts. 4 of these 8 counts are for hate speech. Under section 26 up to A1, A, C, and 2 of the Computer Misuse Act of 2011 as amended, where it is alleged that the said accused person between August 2023 and February 2024 in the areas of Kampala district or thereabout, while using a computer via TikTok account at Pressure 24/7, shared information which is likely to ridicule or degrade or demean and promote hostility against the persons, to wit, His Excellency Kaguta 7, President Republic of Uganda in count number 1, His Majesty Ronald Mwenda Mutebi II, the Kabaka of Uganda in count number 2, Right Honorable Anita Monk, the Speaker of Parliament of the Republic of Uganda, in count number 5, and Honorable Joyce Nabosa Sebugwawo, this is in count number 7. He is said with 4 counts of malicious information, under section 26C, subsection 1 and subsection 2 of the Computer Misuse Act of 2011 as amended. It's alleged that the said accused between the month of August 2023 and February 2024 in the areas of Kampala district or thereabout, while using a computer via TikTok account at Pressure 24/7, shared malicious information relating to the following persons. 1. His Excellency Kaguta 7, the President of Uganda in count number 2. His Majesty Ronald Mwenda Mutebi II, the Kabaka of Uganda in count number 4. Right Honorable Anita Annette Among, the Speaker of the Republic of Uganda in count number 6, and Honorable Joyce Nabosa Sebugwao in count number 8. The accused person denied all the 8 counts and applied for bail through 4 advocates, namely Masaba Raphael Gideon, Tumusime Kakulu, Tumusime Kato, and Ochida Hope. The accused presented 2 sureties, namely Nambozo Brenda, age 35, who operates a cosmetic shop and sister of the accused, Ibrahim Sembatia Matia, age 32, who operates a phone and accessory shop and friend of the accused person. The state, represented by Land's Chief State Attorney Richard Vili Vumbuka, opposed the application on the following grounds. And based on the affidavit in reply deponed by Detective I.P. Pamizo Agre, and the grounds are the following. That the applicant or accused person has no fixed place overboard, that the area local council one chairperson of Church Zone in Najana Nkumbi disowned him in the next C to the affidavit in reply, stating that he has never been a resident of his area. That he was arrested from Excelsis Garden Hotel in Ntinda, where he had lived for 2 months, and that the charge sheet has his residence as Kauga in Mukono, and therefore the accused person's residence is not clear, yet it's a key factor to consider in granting bail. The accused has no credibility given the fact that he has no place overboard, that his chances of absconding are high and therefore is a flight risk given that he lacks a fixed place overboard. Inside the case of Francis Onebe versus Uganda, stating that it would be risky for this court to release an accused person who has no fixed place overboard. It was further the submission of the Land Chief State Attorney that the 2 sureties are not substantial, that Nambozo Brenda, a sister of the accused person, is a tenant at Church Zone without credible source of income, or Mr. Sembata Ibrahim Matia was disowned by the area chairperson of Muzana Zone in Chisenyi, where he allegedly stays. He concluded that the two accused persons, that the 2 sureties have no fixed places overboard, and that numbers of being a tenant can shift anytime, and on credible sources of income. He cited the case of Mogera John versus Uganda. He further stated that the case is of public interest, and he cited the case, the ruling of Justice Tibulia in the consolidated Minister's application 45, 46, and 47 of 2015. It was further the state's submission that the accused will be unsafe outside prison and that the offense is grave in nature. He prayed that bail will be denied, and that if this court is inclined to grant bail, it should impose extremely stringent bail conditions. In rejoinder, Mr. Masaba submitted that the offense is not grave in nature as alleged by the state, as attracts a maximum sentence of 5 years in prison upon conviction. That the AIS chairpersons who disowned the applicant and the sureties were intimidated by the investigating officer. That the state order has enough evidence against the accused person, and that's why we will charge him in court, and that therefore the accused person shall not interfere with the investigations. It was a submission that the sureties are substantial, and that numbers of being a tenant cannot bar her from being a competent surety as long as she can ensure that the accused person attends trial. He confirmed that the accused has a fixed place overboard at Church Zone and Nikakoli Budaka, where he stays during holidays with his mother. He prayed that the court released the accused person on very lenient terms, particularly on non-cash bail. The issue now before this court is whether or not the accused person has satisfied the ground for release on bail. It's straight law that every accused person has a constitutional right to apply for bail, which court has discretion to grant or not to grant in accordance with the law. I have carefully addressed my mind to paragraph 13 of the Constitution, Bail Guidance for Cost of Judicature, Practice Direction of 2022, particularly paragraph 13 on concession for grant of bail. The same paragraph states that the court shall consider the following in handling a bail application. 1. The gravity of the offense. B. The nature of the offense. C. The antecedents of the applicant insofar as they are known. D. The possibility of a substantial delay of the trial. E. The applicant's age, physical and mental conditions. F. The likelihood of the applicant to attend court. G. The stage of proceedings. H. The likelihood of the applicant to commit another offense while on bail. J. the safety of the applicant, the community, and the complainants. K, whether the applicant has a fixed place of abode within Uganda or whether he or she is ordinary resident outside Uganda. L, whether the applicant has sufficient sureties within Uganda to undertake that the applicant shall comply with the conditions of his or her bail, among others. I note that the residence of the applicant is not clear. The charge sheet has his residence as Gauka Mukono, and when the charges were read to him, he never denied this particular fact. Later introducing him came from Church Zone in Najanankumbi, whose chairperson will see one assist disowned the said accused person as case said that not a resident of the area. There is also another letter from Kakoli Nibudaka where they allege that he stayed with Maza during holidays. Upon the police, he was arrested from a hotel in Ntinda where he had stayed for 2 months. In light of paragraph 13(1)(k) of the bail guidelines, I don't find the accused person to have fixed place of abode. The evidence on record shows that he stays in Church Zone, Kauga in Mukono, Kakoli in Budaka, and the hotel in Ntinda. Paragraph 15(1) of the bail guidelines sets out what court has to consider in finding surety substantial, and these include the age of the surety, work and residence address of the sureties, surety numbers of Brenda as a place of work and residence at Church Zone, and Martha, she is a tenant. She's also a sister of the accused person. In light of paragraph 15(1) A and E of the bail guides, I find her substantial. However, suit number to Mr. Sembatia Ibrahim Matia has no clear place of residence, as he was disowned by the area chairperson of the zone where he alleges to be staying. He has no clear relationship with the accused person. A male sister is his friend. And in light of paragraph 15(1) B and E of the bail guidelines, I don't find Mr. Sembatia Ibrahim Matia a substantial surety to stand for the accused person. An applicant who has no fixed place of abode and without substantial sureties cannot be released on bail. If court did so, it would assume a risk as stated in the case of Francis Onebe versus Uganda, which was cited above. I'm not ready to assume this risk for the reasons stated above, and for those reasons I do reject the bail application and further remand the accused the 26th of March 2024 when the case shall come up for mention.
Criminal case number 480. Criminal case.
Hey, it's coming up with. Are you sure? Are you sure? Have you looked at the last minute? Let's wait then.
Kabaka yasoka Ssaabasajja Kabaka teri muvume ne President Museveni ne General Muhoozi kati abalala muvume awangale ayi Ssaabasajja Kabaka awangale Ssaabasajja Kabaka wa Buganda ali mukwatako kumuliisa effumu businze bene abasajja bo gye tuli ku ground tugenda kulwanirira obulamu twabuwaayo dda eri Ssaabasajja Kabaka neddira musundisi mukodomi wa Kabaka bambi waliwo omuvubuka gwe bakutte tebamututte mu bukyamu bamuyita UG naye interview ngenda gibaweera wali atutuluma wali wabweru bana tugondera amateeka
nnono kubanga nange yagenda mu mawanga amalala n'akulumba n'olwekyo mbadde nsaba gavumenti eya wakati awamu n'obukulembeze obw'emmengo tutuule mbawabule kubanga nze Katongole nze ntongoze ebikoze eki ebiwedde mwe kubanga mawulire mugende mugula oluyimba lw'aba student buli Katongole aba yeddira nte ne bw'omutumwa mu lugavendu gw'omugwako n'olwekyo gwe muwuliza munnange oba mulabe munnange oba gwe atambula n'ebyobuwangwa n'ennono naawe weegayirire ekintu kino kiyinza okukkiramu kati ku ssaawa eno kiri ku munnaffe ate ataliwo wano mu Buganda ennono ekukozesa Mayanja asobola okukwambala, Kibuuka asobola okukwambala, Junju asobola okukwambala ne Kiwanuka. N'olwekyo nsaba bakama bange bonna mu ntiko mu gavumenti eya wakati awamu ne mu bukulembeze bw'Emmengo. Naddala Mama Fiina ensonga eno ekwatako noonya nange nkunoonye otuuse obubaka naye Uganda eyimiridde ku remote ku buwangwa n'ennono. N'olwekyo amannya gange nze Katongole gutanyweke bwe tubeereyo mu busiraamu mpita Musa eno mu bukatuliki mpita Moses. N'olwekyo mpanisa nnyo omukono ow'ekitiibwa omulamuzi nsobole omweyanjulira naye kinkoze bubi sisobole kukola ki kwogera mu kkooti naye nga enkundi eriwo bwa Maama Nakayima okuva Mubende mu batembuuzi bwe busitudde enkundi bano abaana balwana kulaba ng'obuyinza bwa maama waabwe buddayo ku ntikko. N'olwekyo mbadde nsaba era mwenna abajjako e Mubende Kyagulanyi lwe bagenda ne Ssaabasajja Kabaka bampita erinnya kuba Ssaabasajja yalina amannya erinnya bampita Lumala Twalibu nga ndi mukoddomi wa Kabaka. Omulimu gwe tukola mu Lubiri ffe tufumbira Ssaabasajja Kabaka neddira musu kyanaku nnyo ne tutooboolwa ate bano abaana bagezi aba bapuresha balina akabinja kaabwe wovaayo bwoti n'oyagala oyogere nti ani oyo akutte ku Buganda bambalira gwe. Social media luliza aleeta nnyo nze nga nyambadde olubugu banyambalira ne banteekako gw'obutemu nti natta abantu naye nange sisituse sebase nsitukiddemu ne ŋŋamba oyo eyaŋŋamba nti natta abantu tugende mu kkooti era leero mukutte ne mumutwala mu mikono gy'ab'obuyinza tumutwale mu kkooti andage gye nattira abantu baagala okutujja ku mulamwa bannange temutya temuggwamu maanyi bakadde baffe baafa lino eggwanga Buganda esobola okuggwawo etya mpola Kabaka yali tayisibwamu maaso naye omwana yazze atulaga nti Kabaka basobola omuvuma Kabaka avuma gusinze Ssaabasajja Kabaka ali kukaabya amasiga tuli mukaabya omusaayi ali kukwata embazi nakugezaamu tuli mufumisa fumu. Nze mukoddomi we Lumala Twalibu nja kubeerawo mbeerewo paka buli ekinavaayo neddira musu kanfe kuba ab'ekika kyaffe bonna abatulwanirira okubeerawo baafa si wano oka mu Buganda batandika mpola olunagira nga batandika Kabaka wa Busoga. Omusoga yaŋŋambye gwe n'okwata ku Kabaka wa ku kyalo bakugobako lwaki tebamugoba ku kyalo kyekibonerezo bamugobe ku kyalo basonyiwe bamugobe ku kyalo aveeko agende puresha asooka ayige katusooke naffe tumuteeke ku puresha ng'erinnya lye tumuteeke ku puresha buli muvubuka wa Buganda aveeyo ow'Enkole aveeyo ow'Ebusoga aveeyo kuba neeyo kijje wamu tusooke tumuteeke ku puresha. Nze mulabye takyalina mutwe nze ogwange munene naye takyalina gugwe. Abantu batyoboola ogula akasimuko n'otandika okutyoboola. Edda bakadde baffe baazanyanga Sonko na Dduulu tetukyalina we tuzanyira tuyina amasimu gaffe ge tuzanyisa naye tulemera okuzanya emizanyo ku simu zaffe notandika okutyoboola abantu abakulu ate wetumala batyoboola tuleeta byabufuzi. Nze newe mba mpagira ekibiina ekirala ekikwatagana ku Kabaka twambuulira biri ebibiina nsuula eri nensooka maliriza obwakabaka awangale ayi Ssaabasajja gusinze
yenanyini sitamanyirwa nyanja temanyirwa kalala nkoma fumulyewubira mbwembula
kikomeko Fred ow'Eganda musajja wa Kabaka tetuyinza kukkiriza okumuyisa okutyoboola Obuganda nga batunyomoola tetujja kukkiriza okutuyisaamu olugaayu n'okutumanyira tetujja kukkiriza ng'Abaganda era tuli bumu n'abaganda bonna mbakubira omulanga mwenna abali eyo mujje akasajja kalome kadda mu kkooti tuddewo tubeerewo tulabe akasayirwa omusango nga bwe tubaddewo olwaleero era mbasaba mujjenga mu bungi tubeerewo kasayirwa omusango mu mazima n'obwenkanya kategeere nti ssaabasajja wa Buganda tayisibwamu maaso tamanyirwa empologoma ya Buganda terina kumanyirwa nga weetuli ali mukaabya abaziga tuli mukaabya omusaayi
balamusiza nnyo erinnya Bawanga Nantaba ngamba mu Buganda kwe kwaffe kino ekiri mu ggwanga oba ekiri mu Buganda bamaama b'eggwanga musudde nnyo obuvunaanyizibwa tetukyawa baana budde kubatereeza kino kye mulaba ekiri ku mwana oyo muzadde kusuula buvunaanyizibwa bwe bazadde bannange bamaama musudde nnyo obuvunaanyizibwa bwammwe mulese emirimu gyammwe abaana bafuuse ebisekererwa abaana bafuuse ebitategeerekeka kino kiriwo lwa muzadde kubeera nti teyatwala buvunaanyizibwa bwe bazadde bannange kino kye tugenda okulaba si muzadde woyo omwana yekka naawe muzadde munnange ali eyo bw'otootwale buvunaanyizibwa bwo omwana bw'otamukaabya mu buto akukaabya mu bukulu nsaba tudde emabega tweddaabirize tweddaabulule abazadde tuddemu tutuuze abaana tubakuze mu nkuza entuufu bamaama ffe tuyina omulimu gw'okukuza abaana naye abaana tubasuuliridde nsaba bannange mwenna abakuŋŋaanye ne tujja ku kkooti okubugiriza omusango guno nsaba tetuggwamu maanyi era twekunge tukomewo Buganda esigala Buganda kuba tuli baganda ba Katonda guno omulembe gwaffe gwavuka tulina okulwanirira Buganda lwazi naye nga naffe tugirwanirira awangaale baffe